Hi everyone. This video will review the most common return to school measures being adopted across the country, including contact tracing, face coverings, temperature checking and recording, and isolation and detention of children who are suspected cases of COVID-19. Firstly, I want to say thank you to all of the parents who sent me copies of their return to school policies. I received over 100 different school protocols, meaning that under the cover of this video, it is possible to provide advice in relation to the most common measures being adopted by schools across the country. Now, before I get into the return to school measures, I think it would be helpful to give you a brief overview of the general data protection regulations, as many people continue to state that certain measures being adopted by schools and places of work do not comply with data protection. The General Data Protection Regulations, which came into force on the 25th of May 2018, lay down rules relating to the protection of persons with regard to the processing of their personal data, which under a special category of data includes health data. Article 8 of the EU Charter of Fundamental Rights states that everyone has the right to the protection of their personal data, and such data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. This is the main issue that I wanted to point out. Many people mistakenly think that organisations must get the individual's consent in order to legally process their personal data. However, with regard to health data, consent is only one of 10 lawful grounds for processing such data, meaning that your consent is not always required. This is important with regard to issues such as contact tracing and checking temperatures. So let's take a brief look at the lawful grounds for processing your health data. 1. Where you give your consent. 2. For employment reasons. 3. To protect the interests of a person who is physically or legally incapable of giving consent. 4. Where processing is carried out by a not-for-profit body with a political, philosophical, religious or trade union aim. 5. Where the data is manifestly made public by the data subject. 6. For defence of legal claims. 7. For reasons of substantial public interest. 8. For reasons of preventative or occupational medicine. 9. For reasons of public interest in the area of public health. And 10. For archiving purposes in the public interest, scientific or historical research purposes or statistical purposes. So, for confirmation, schools and places of work are permitted to process your health data without your consent, if such processing falls into one of the exceptions just noted, which, as I said, includes where the processing is necessary for reasons of public health. So, to be clear, data protection law is not an impediment to issues such as contact tracing and temperature checking, but in fact provides a lawful mechanism for organisations to secure this data without your consent. This is just something to bear in mind as we go through the return to school measures. So the first issue that we're going to discuss now is contact tracing. Most return to school policies include a section on contact tracing, which will apply to pupils, teachers and anyone who might need to enter the school premises, such as parents or contractors. If you do not consent to your or your child's data being processed for contact tracing, the school must establish another legal basis for processing such data. Given that the COVID-19 response plan for the safe and sustainable reopening of primary and special schools and post-primary schools specifically requires contact tracing, and this request is in line with the HSE recommendations, it is likely that the processing of such data would be considered lawful under Article 9I of the General Data Protection Regulations, under processing is necessary for reasons of public interest in the area of public health. Personally, I do not see a way around the issue of contact tracing in schools apart from not allowing your child to go back to school. The second issue that we'll look at now is checking temperatures. Many school policies say that they will check pupil temperatures each time they enter the school building. As stated earlier, there are 10 reasons set down in law which permit the processing of health data. One being consent. So if you do not consent to your child's temperature being taken, the school must look to one of the other legal bases to process such data. In all likelihood, the school will suggest that processing this personal data is necessary for reasons of public interest in the area of public health. However, if we look to a recent publication by the Data Protection Commissioner with regard to temperature checking in the workplace, we can see that the Data Commissioner would only consider temperature checking in workplaces necessary and proportionate in circumstances where public health authorities or other relevant authorities are recommending such measures. We can use this same argument and logic with regard to considerations around temperature checking in schools. I note that the COVID-19 response plan for the safe and sustainable reopening of primary and special schools and post-primary schools makes no reference to a requirement to check a child's temperature. Therefore, unless your child's school has been identified as particularly high risk, the school in question must justify why any consequent processing of personal data is necessary. That said, in order to maintain an element of civility with your child's school, you could suggest a workaround, which might include advising the school through a declaration that although you do not consent to your child's temperature being taken, that in the interests of public health you shall commit to taking your child's temperature every morning before they leave for school, and shall further commit that you shall not send your child to school in the event that their temperature is above average. If you wish to utilise this option, I have prepared a non-consent declaration form which you can find at the Google link in the description box to this video. The third issue that we will look at now is face coverings. Firstly, I have not seen any primary school policy which calls for face coverings to be made mandatory by pupils. In the event you have received confirmation that face coverings are required to be worn by pupils in primary school, please see the latest HSE advice titled COVID-19 Interim Guidance for the Use of Face Coverings in Childcare and Educational Settings, dated the 6th of August 2020, and the Department of Education's Reopening of Primary and Special Schools Procedure. I've included a link to these documents in the description box of this video. Both of these documents confirm that the official government and HSE policy is that children attending primary school or preschool childcare settings should not wear face coverings. Supplying this information to the school principal should be enough to deter any principal from implementing a policy of mandatory face coverings in primary schools. With respect to secondary schools, every return to school policy I have reviewed contains a requirement for teachers, staff and students to wear a face covering when a physical distance of 2 meters from other staff or students cannot be maintained. The only exceptions to this requirement are for persons with breathing difficulties, persons who are unconscious or incapacitated, persons who are unable to remove the face covering without assistance, or persons who have special needs and who may feel upset or very uncomfortable wearing the face covering. I find the exemptions under the school policy to be disturbing, as they are starkly different to the exemptions under the public transport and relevant premises regulations, both of which make allowances for persons who would suffer severe distress by having to wear a face covering. In my view, the policy being adopted by the Department of Education with respect to face coverings is discriminatory to those who might suffer from a disability, which makes it impossible or uncomfortable for them to wear a face covering at school. For the sake of completeness, I confirm that under the Equal Status Acts, a disability means A. The total or partial absence of a person's bodily or mental functions, including the absence of a part of a person's body. B. The presence in the body of organisms causing or likely to cause chronic disease or illness. C. The malfunction, malformation or disfigurement of a part of a person's body. D. A condition or malfunction which results in a person learning differently from a person without the condition or malfunction. Or E. A condition, disease or illness which affects a person's thought processes, perception of reality, emotions or judgment, or which results in disturbed behaviour. In circumstances where you believe your child should be exempt from the requirement to wear a face covering at school, I would suggest that you write to the school and advise them of the exemptions under the public transport and relevant premises regulations, and confirm that the exemptions set out therein were necessary to ensure that persons did not suffer discrimination in the provision of goods and services. and advising of your concern that the school would appear to be openly and actively discriminating against children who have valid reasons for not wearing face coverings by not including an exemption for severe distress. In this regard, you can also advise the school of your child's constitutional right to free primary education, and that expelling any child from school because they cannot wear a face covering in circumstances where they suffer from a disability as defined in the Equal Status Acts would likely be considered illegal. To assist, I have drafted such a template letter and parental declaration setting out your child's exemption from the requirement to wear a face covering while at school, which you may find at the Google link in the description box of this video. This letter may be enough to encourage the school to accept reasonable exemptions. However, I have seen letters issued by some schools this week advising that a child will only be exempt from the requirement to wear a face covering at school if they have a certificate from their GP. Therefore, I would suggest that in addition to the above, you also contact your GP to seek an exemption certificate where possible. The final issue I'm going to discuss is the isolation and detention of children who are suspected cases of COVID-19. At the outset of discussing this issue, I would say that I am relaying the law in this area as I interpret it. But I would also caution that just because the law allows for a particular course of action does not mean that the school will follow this course of action. The majority of return to school documents I have reviewed contain the same wording as to how suspected cases of COVID-19 will be managed, with only one section giving rise, in my view, to concern. This is the statement that the school will assess whether the pupil is well enough to go home with their parents, or where the school decides the pupil is not well enough to go home or requires advice, that they should contact 999 and inform the emergency services that they have a suspected case of COVID-19. It is this statement that has many parents concerned that children who are suspected of having COVID-19 may be detained, isolated and tested for COVID-19 without the parents' knowledge or consent. Within the return to school documents, I note that the section as to possible detention of children is vague and could easily be overlooked by those scanning through the return to school document. I am not sure if this vagueness is intentional to detract from attention or unintentional, as the school has no intention of detaining pupils without parental consent. It is probably not possible to conclude how schools will practically manage suspected cases of COVID-19 until they happen. That said, we will consider the law in this area so you are fully informed as to the rights of schools in this regard. So far in 2020, the Irish Government have enacted 13 Acts of the Oireachtas and 313 statutory instruments. The first Act of the Oireachtas to be enacted in 2020 was the Health Preservation and Protection and Other Emergency Measures in the Public Interest Act 2020. This is the act that conferred power on the Minister for Health to make regulations to restrict movements and close premises during the lockdown. This Act at Part 3, Section 11 also deals with the detention and isolation of persons in certain circumstances. This is the section of the law that you must consider in determining the rights of schools to detain and isolate persons suspected of having COVID-19. In reviewing this legislation, the first consideration is whether a child is considered a person under this Act. You will note that Part 3 of the Act amends the Health Act 1947, so first we must look to the Health Act to see if a person is defined therein. Having reviewed the Health Act, I confirm that there is no definition for person, but that there is a definition for child. A child is considered a person who is less than 16 years of age. There is also a definition for adult person, which means a person who is 16 years of age or older. As we can find no definition under the Health Act, we may now look to the Interpretation Act to see if the word person is defined there. On reviewing this legislation, we find that under Part 4, Meaning and Construction of Words and Expressions, that the word person is defined as importing a body corporate or an unincorporated body of persons as well as an individual. So now we know that a child is considered a person under the Interpretation Act. The relevance of this is that the provisions of Section 11 of the Health Preservation Act can now be said to apply to children in the same way as it applies to adults. So let's now take a closer look at Section 11. This section is operational until the 9th of November 2020, unless a resolution approving its continuation is passed by both houses of the Oireachtas. Section 11 amends the Health Act 1947 by inserting a new clause 38A, which at subsection 1 provides that if a medical officer believes in good faith that A, a person is a potential source of infection, and B, the person is a potential risk to public health, and C, his or her detention and isolation is appropriate in order to 1, prevent, limit, minimise or slow the spread of COVID-19, and to minimise the risk to human life and public health, and D, such person cannot be effectively isolated, refuses to remain or appears unlikely to remain in his or her home or other accommodation arranged or agreed by the health service executive, the officer may in writing order the detention and isolation of such person in a hospital or other place specified in the order until such time as the medical officer certifies that the person's detention is no longer required for the purposes of this section. So the important points to note here are: number 1, the school does not have the authority under the law to detain your child. Only a medical officer can make this determination. That said, I would advise that you ensure that the school has the most up-to-date contact details for you, and be sure to answer your phone in the event that the school calls. And 2, if you agree that you or your child will remain in your home, it is unlikely that you or your child will be isolated in a hospital or other place or become the subject of an order made by a medical officer. The next important section of note is section 38A4, which makes reference to the person who is the subject of detention also being subject to medical examination as soon as possible, and in any event not later than 14 days from the time the person has been detained. The next section of note is section 38A7A, which provides that subsection 4 of section 38 of the Health Act 1947 applies to the detention. This subsection 4 states that a person to whom an order under this section relates and who A, resists being detained under this section or resists being brought under this section to the hospital or other place specified in the order, or B, willfully misbehaves while detained in such hospital or other place, C, escapes or attempts to escape from detention under this section, or D, does not submit himself in a peaceful and orderly manner to the exercise of any power conferred by this section, shall be guilty of an offence. Section 7 of the Health Preservation Act also confirms that any person, such as a parent or a guardian, who 1, prevents or attempts to prevent the detention or the bringing to a hospital or other place of any person who is subject to detention and isolation under the provisions of this section, 2, assists in an escape or an attempted escape of any person who is subject to detention and isolation under the provisions of this section, or 3, obstructs or interferes with the exercise of any power conferred by this section, is guilty of an offence which might expose them to a fine of up to €2,500 or 3 months imprisonment or both. This means that if a medical officer believes that your child cannot be effectively isolated, or in circumstances where your child refuses to remain at home, it is possible to isolate and detain your child in a hospital or other place, carry out a COVID-19 or other test on them, and in the event that either your child or you as the parent impede any of this, you will be guilty of an offence. The next section of note is section 10. You might recall that under section 38A1, in order for a person to be detained and isolated, they must be a potential source of infection. This section 10 defines what a potential source of infection means. So a potential source of infection means, in relation to a person who meets one or more of the following criteria. A person has been in recent contact with a person whom the medical officer of health believes in good faith to be 1, a probable source of infection of COVID-19, or 2, suffering from COVID-19. B, a person who has attended an event which the medical officer of health believes in good faith was attended by a person or persons who 1, is or are a probable source of infection with COVID-19, or 2, is or are suffering from COVID-19. C, a person who has travelled from or been in contact with a person or persons who has or have travelled from a place outside the state that the medical officer of health believes in good faith to have a significant number of cases of infection with COVID-19. D, a A person who has travelled from, to or within, or has been in contact with a person or persons who has or have travelled from, to or within a geographical area to which an affected areas order applies. Or E, any other person whom the medical officer of health believes in good faith to be a potential source of infection with COVID-19. You might question how the Irish government have the power to isolate, detain and test children without parental consent. In my view, this is possible due to the inclusion of Article 42A in the Irish Constitution, arising from the children's referendum in 2012. You might recall that in 2012 there was much talk about the government not having the power to step in quick enough in circumstances where parents were neglecting their children. And this lack of power was compounded by the state's duty under Article 41 to protect the family. The new Article 42A recognises that children have their own rights and provides that the state may step in the place of parents to protect the rights of children. It is said that the wording under this new article will allow the state to step in quicker when the state believes that the safety or welfare of a child is likely to be prejudicially affected. For completeness, I confirm that Article 42A.2.1 provides, in exceptional cases where the parents, regardless of their marital status, fail in their duty towards their children to such extent that the safety or welfare of any of their children is likely to be prejudicially affected, the state as guardian of the common good shall, by proportionate means as provided by law, endeavour to supply the place of the parents, but always with due regard for the natural and imprescriptible rights of the child. So the first condition to be met is that the case must be exceptional. I am happy that given the measures the government have been able to introduce to date around the lockdown would greatly assist in their argument that isolation, detention and testing of children due to COVID-19 is exceptional. The second condition is that the parents must be said to have failed in their duty towards their child. Again, I believe the widespread support for the government measures will give the government the confidence to state that any parent refusing to test their child in circumstances where their child is a potential source of COVID-19 is failing in their duty as a parent. The third condition requires that the failure in duty by the parent is likely to be prejudicial to the welfare of the child. The word likely means probable, and this is not a high bar. All of that said, I believe that we should think practically about the consequences of any school detaining children without parental consent. Although this is permissible in law as set out above, no parent, even those who agree with the government measures, would send their child back to school the following day if widespread detentions were taking place. Furthermore, if widespread detentions of children were taking place, in my view, this would give rise to large-scale protesting. And this is another issue that we know the government would not like. I hope I'm not proven wrong, but I do not believe that there will be widespread isolation and detention of children. And I say this given how the government have enacted all COVID laws to date. With all laws, they have tested the water. For example, the initial operation period for the lockdown was only 4 days. Masks were not mandatory and then they were mandatory. Every time the Irish government has considered implementing laws to take away your freedom or instruct the Gardaí to act on those laws, they have looked to the public for approval. And at every occasion to date, the public has widely given that approval. So, in my view, the most productive measure to ensure that no child is isolated and detained is to write to the school confirming that you do not consent to any such measures. And in the event that you hear of any child being isolated and detained, we must band together to illustrate our disapproval of this decision to ensure this practice does not become the new normal. I have drafted a template non-consent to isolation, detention and testing that you may use if you wish. I've included a link to this document in the description box of this video. Finally, you might recall that when we started looking at the question of detaining and isolating children, this concern arose due to the wording in many return to school documents which stated that the school would decide if the child was well enough to go home with the parents or whether their condition required the school calling 999. I believe it is very important that as parents you clearly distinguish what is and what is not an emergency situation which requires the school to phone emergency services. In this regard, within the body of the template letter I have prepared, I have set out the circumstances under which 112 or 999 should be called by using the examples of what the HSE considers to be emergencies, and advising that in all other cases, you as the parent shall make the decision to contact your GP or other doctor. Finally, I wanted to make a short list of other items that as parents you should be aware of within the return to school documents. 1. Schools have committed to teaching and training children on COVID-19 health advice and new guidelines and laws as and when they become available. My advice is to know what your child is being taught and ensure you also educate them at home. 2. Hand washing within schools, touching surfaces, touching faces will all be monitored quite strictly. My advice would be to educate your child on these matters to ensure that they do not develop an unhealthy oversensitivity to bacteria or viruses. 3. One school has introduced facial recognition for roll call, temperature checking and mask checking. I find any such technology very intrusive, and considering you as parents are unlikely to be allowed into your child's school due to COVID restrictions, it would be wise to ask whether your school is introducing similar measures. And 4. Most schools talk about the need to leave windows and doors open as much as possible. You should discuss the appropriateness of this coming into the winter months, as doing this is more likely to lead to increase in flu-like symptoms, which might lead to your child being incorrectly diagnosed as being a potential source of COVID-19. Lastly, I just wanted to apologise for any emails I've not returned. I am receiving a couple of hundred requests for help and advice every week, and it is simply not possible to respond to everybody. Thanks for watching.